Okay. All right, last panel of the afternoon. We're going to try and keep everybody awake. I hope you had some sugar and caffeine. That certainly helped me. Standing up will also help. The person who snores the loudest from the dais gets a bad grade. In any case, we are now moving on to private actors and human rights online. We've already been touching on that in the last panel and really all day, but we're going to drill down a bit more from perhaps some angles that are fresh, but also continuing on with some conversations that started in the last panel as well. Just very quickly to introduce who's sitting here, and again, I'm not going to recite anybody's full bios, but if you feel that there's extra information that you'd like to share about what you do that's relevant to what you're going to say, please go ahead and share that. To my immediate left, we have Ona Flores, Office of the Special Rapporteur of the the acronym is IACMHR, but it's the Inter-American Court Commission on Human Rights. That's right. Thank you very much. There will be a quiz on all the various commissions on human rights and their acronyms after class for extra bonus credit. And then we have Bertrand de la Chapelle from the Internet and Jurisdiction Project. To his left, we have Chinmayi Arun, National Law University in India. To her left, we have Yaman Akdeniz. Did I spell that? I pronounced that correctly. From Istanbul Bilgi University in Turkey. And to his left, we have Christopher Bavitz from the Berkman Klein Center at Harvard. And to his left, and this is with one panelist having left us sick, so it could have been an even bigger panel. So to his left is Peter Stern from Facebook. So it's going to be a very interesting conversation there. So I'm going to start with Bertrand because not only because in one of the lists I was given you were second after Molly, who was supposed to go first, and she was sick, but also because your perspective, I think, feeds very well from the previous conversation about we have this situation where we have private multinational actors that are shaping expression online, and we have governments that are making demands and attempting to regulate these private multinational platforms and networks, and oftentimes making demands that conflict with one another. One government trying to regulate in one direction and the other government trying to regulate in another, and all having cross-border implications beyond the jurisdiction of the government in question. And then sometimes you have stakeholders saying a third thing. So human rights groups might be telling the platforms, you have to do this, and one government's, so the human rights groups say you have to do X, the government A says you have to do Y, and government B says you have to do Z, and what does the company do in this? What principles do they build upon to figure out what to do and to weigh the consequences? Because of course the governments impose consequences on the company's ability to do business in a market or to reach users, and also the governments, for instance, when a government is imposing either privacy regulations or regulations related to the takedown of speech, it has implications for users far beyond the borders of that jurisdiction. So, Bertrand, you're involved with an effort that I've had some involvement with to figure out what the governance norms and standards might be in this space, and thinking about how governance might evolve from something of the mess that it is now. And so since our theme is private actors in particular, and the way in which private actors should both govern themselves, govern what is allowed and not allowed on their platform, and then being the objects of governance. What do we want companies to do, and what do we want governments to do in order to have a result that enables the respect and protection of freedom of expression for everybody on the planet?
Small ordeal. I think this panel, first of all, I'm Bertrand Lachapelle. I'm the Executive Director of the Secretariat of Internet and Jurisdiction Policy Network. I find that the end of the last panel was a perfect segue to what we're discussing here, because those issues are essential, but they're essential because there's an underlying question that we actually do not formulate fully so far, which I think is completely in line with what Toby was mentioning and what Rebecca were saying as well, which is, what is the digital society that we want to build together? And when I say together, it's what is the digital society and the rules for the digital society and the way they are implemented, the way they're developed, and the way they're enforced for a community of 2, 3, 4, 5 billion people spread around the world in different jurisdictions. And so what I want to do very quickly as an introduction is basically to highlight first why we're talking about this, like factually. The second thing is a few trends that have emerged in terms of the principles. The third thing, and the most important, is getting to concrete issues, because we need to be moving towards very concrete sub-issues so that we can progress, and quickly finish how to move forward. Generally speaking, the reason why we're here is because the landscape has transformed considerably. It's obvious, but it's worth repeating. We started with a World Wide Web that was completely equal footing, very distributed, and no particular norms. And we now are in an environment where the power law distribution gives an incredible responsibility and proportion of activity to major actors that are private actors and are transnational, and mostly based in the US, by the way. I don't have to come back on the change in scale, speed, and reach, and virality of all the information that can be circulated. But more importantly, those platforms are far away now from what was the initial description of hosting entities that led to the whole rules of the Section 230 and the e-commerce directive. That's a fact. Not to say that they should be considered as traditional media either. They're in an intermediary space, and I think everybody is accepting this and recognizing it now, including the platforms. What is important also in the change in the landscape is that we're confronted with things that we didn't expect really a few years ago. It's the fact that a lot of people, or a certain number of people, are voluntarily using those tools to exacerbate existing or pre-existing lines of fracture. Political, ethnical, religious, whatever. And wherever there is an opportunity to change this and to influence those lines of fractures, there are groups that are intent on doing this. And this is something new in a certain way. It's like volcanoes that have been erupting one after the other, and unfortunately the news cycle gives the peaks one after the other. So you got terrorism, and then you got revenge porn, and then you get fake news, and then you get hate speech, and then you get... Last one was Myanmar, and it goes on and on and on, and most of the actors are actually reacting to this. There's no planned capacity to really anticipate all those things. The end result is that the attitude of governments, and this is what the main change has been, is that there's now a pressure that is extremely strong over those gatekeepers because they have a capacity to influence and they have a capacity to act, that the governments who cannot necessarily enforce their own national laws across their borders are actually asking the platforms to do the work for them. And this raises a certain number of questions regarding the responsibility of the respective actors and whether this responsibility should go further. What I want to finish on this first point is we need to agree, I hope, that the problem we're confronted with now is that we all be it activists, be it platforms, be it governments, between users, we are confronted with the challenge of reconciling three objectives. We want to fight abuses because it harms people, and it's a human rights challenge also for individual users. We want at the same time to respect human rights in the way we fight the abuses and develop this in a way that enables the growth of the digital economy and the cloud services. This is a big conundrum, and no single actor is able to do this. So, once again, the challenge is, how do we set the norms for the digital society? Who implements them and who enforces them? Quickly, a few trends. Human rights principles, the Universal Declaration of Human Rights, clearly are the foundation. Second, so far, Section 230 and the e-commerce directive are still holding with the principle of notice and take down, or non-liability unless there is inappropriate non-reaction. I think the principle of proportionality should be considered as a given. It is something that we must consider as the foundation of what needs to be done. More importantly, the terms of service of the major platforms have evolved from what was labeled by one of the interlocutors at the platforms that we discussed with a few years ago, and pardon my French, as cover your ass policies that were drafted by the legal department in the basement and nobody cared about, to something that has become the de facto constitutions of these online spaces, with all the consequences that it represents. And it's a big change, and it's a big evolution. And finally, those terms of service, and we can elaborate more afterwards, have an extremely important role today in global norm harmonization. Without belaboring, when you listen to the testimony of Mark Zuckerberg in Congress the other week, when he says the GDPR is a fact, we will have to implement it because it's a market, I paraphrase of course, it is a market of 500 million people. And because we would like to have as uniform terms of service as possible globally, because it's easier to manage, therefore I will more or less expand those privacy protections worldwide. This is an amazing harmonization trend. How much it will be effectively implemented is another issue. But the interplay between norms, national laws, and terms of service is a very important element in terms of the harmonization. And finally, the notion of more responsibility for platforms is clearly in the air, including from the platforms themselves, because the pressure has been strong. So you were asking, Rebecca, for...
What do we do?
Sorry, no, it was Agnes.
What do we want everybody to do?
No, Agnes was asking for positive and almost optimistic things in the future. I always like to quote the inventor of the European Union, or what was the foundation of the European Union, who said, "I'm not optimistic, I'm determined." And I think the challenge that we have now is exactly the question that emerged in your presentation of the digital rights ranking report. What is at stake is, what are we collectively asking people to do? And this question is a very difficult one. And the only solution is basically to address a few concrete questions, sub-elements that are operational and where cooperation and mistrust can be overcome between government, civil society, the private sector, academia, international organizations, and even technical operators in some cases. Let me give you a few that you're all aware of, but I highlight them because in the process that we run for Internet and Jurisdiction, there was a conference in Ottawa in which a few of you participated in February. And the goal was to get an agreement by this community on a certain number of subtopics. And a few of them are, how do we deal with the question of the geographic scope of content takedowns? That goes for the right to be de-indexed, but that goes for more general attacks against human rights in a global nature. Second, what is the process for evaluating de facto the illegality of a particular content according to a diversity of 190 laws? Is it the internal teams of the companies, or should we invent, as was mentioned at the end, something more innovative with advisory bodies that will review in a cooperative manner how those controversial content should be treated? And I can point you in particular, the recent law by Germany, the NetzDG, has been mentioned before. You may have read in the press that as part of the sort of already review of this approach, the notion of having independent advisory body that would be set up by the companies and maybe other actors to review this and provide avenues for redress is something that is considered valuable. Finally, the question of monitoring. This is not in the e-commerce directive that prohibits general monitoring. This is becoming a very important element. How much proactive monitoring could do? And in that regard, what was mentioned before, the role of artificial intelligence and algorithms is becoming absolutely essential. So, next and final element, all the procedural guarantees that ensure potentially that in this direct relationship between governments and companies, but also users and companies, there are elements of notification when there's a takedown, the formats for requests are sufficiently detailed, that there are avenues for redress, for remediation, all those things that we take for granted at the national level, but that do not exist at the transnational level. So, in a nutshell, that's what we've been trying to do in Internet and Jurisdiction for about 7 years now. I must share, and I hope that's a positive element, that as we see the different silos that so far are being working completely in an uncoordinated manner, I see a potential coherence emerging on the need to develop those things. The only question is how to overcome, as I said, the mistrust between these actors and bring them around the same table, because no single category of actor can actually solve the problem. I stop here. I've already been too long, but sure. It's...
Thank you. That's a really useful framing. I'm going to move on to Chinmayi for the perspective from India and really beyond. You know, kind of when you go beyond sort of the U.S. platforms and the European regulators, what's the perspective from quote unquote, as sometimes is even called in business circles, the rest of the world. But you know, I've actually seen that as like, you know, when you know, some companies are thinking about, you know, different parts of the world, it sort of kind of goes in these layers. But in the global south, in countries like India, you know, people are very dependent on Facebook. Of course, you know, what's happening with regulatory frameworks in Europe are having a huge impact, both on the platforms people are using, but also influencing the types of laws that might end up being enacted or repealed or changed in different ways. And so interested to see, just kind of from your perspective, what do you want the companies to do? What do you want both your own government, but also other governments to do in order to create a transnational internet that's going to serve the rights and interests of everybody?
Thank you, Rebecca, especially for From the Rest of the World, which I promise you I'm going to use for an essay title soon.
You wrote that in an email, I think. So.
Oh, really? Okay, now I feel happier. It didn't sound like me, but this is great. Just to continue in the vein of the cheerful Indian perspective, as Vidushi has set the scene, I'm going to respond to your question in 3 stages. One is context setting, which is actually like a description, like literally from the rest of the world. And how, in many ways, well, firstly, one should care about it just because it's happening, but also I think that we're beginning to see trends in which these parts of the world are a bit of a tinderbox, and then the same problems migrate to parts of the world that are sort of more central to the company's thinking, and suddenly it becomes an explosive problem, whereas the truth is it always existed. The second thing that I want to describe in this context is that the government-company relationship is changing. And that's to respond a little bit to the things that Bertrand was saying, but also to your question of what do we want to see. And I'm actually beginning to question whether it's wise to push governments and companies to come up with a solution by themselves, because my guess is we're not going to like it. And the third, of course, is that especially in a room like this, I think we are largely agreed on the kind of values that we're looking for. And so I want to conclude by talking about how you operationalize those values, because I think that the difficulty that I've had over 5 years of work is that we're all happy to say human rights matter, but it has to go further than just saying that human rights matter. And I think that your work, Rebecca, is so valuable from that point of view, because it gets into granularity. So I'm the executive director of the Center for Communication Governance at National Law University, Delhi. And what we do over there is we work on civil liberties, mainly the rights to freedom of speech and expression and privacy of Indian citizens, which involves a certain amount of domestic engagement, but also increasingly engagement with international institutions and with companies that end up influencing the rights of citizens in India. And so I'm coming from that point of view. I always like to point out to people that the profile of companies' users have changed over a period of time. So I loved the map that Rebecca showed us this morning when she was discussing the RDR report. And as you might all have noted, most of the world was blue, blue for Facebook and blue for Google, because these are the platforms that are being used in a lot of the countries around the world, with a few exceptions. But here's the other interesting thing that's happened over time, right? The company's user profile has changed. So for about 2 years, every time I saw community guidelines, I'd say, well, who's the community? And the answer to that question was usually, we're picturing, someone American. Except that this year, the number of users in India of Facebook is the most in the world. So it's India, the US, Brazil, Indonesia, Mexico. Right? And so now we're thinking community. Community is obviously a different sort of beast. And I say that to point to context and why context is difficult, right? And this is something that I will freely admit, this is not an easy problem to crack. I think that most people in this room would look at a photograph of a young woman standing in a pub in jeans, drinking a glass of beer, and you'd be like, well, what could possibly be dangerous about that picture, right? If you show that picture without the young woman's consent to particular communities, just particular communities in India, Pakistan, other countries, it could mean that her life is in threat. And that's not something that would immediately occur to somebody that hasn't grown up in those parts of the world. It's not even something that would necessarily occur to me, having grown up in a liberal bubble in Bangalore in India, right? And so this is what I like to refer to as a hyperlocal problem, where even if you have experts that are diverse, that are from the elite strata of countries around the world, you might still miss speech that is actually quite dangerous. And the reason is that the context of that speech can sometimes be hyperlocal rather than just merely local to the country. So that's one. Two is that I think that there are two different threads that have actually emerged from the conversation that we've had today, stating the obvious a little bit. But on one hand, we've got the platforms playing the role of media in the classic sense of the public sphere, journalism. It's a public space. People are getting political information from there. But it's also mixed with actually very interpersonal communication. And that's where your young woman with a glass of beer comes up. And to negotiate, again, the difference between those kinds of speech, the idea that sometimes speech starts as one kind and then becomes the other kind, it can be difficult for platforms. And the application of standards, again, is not easy. and I'm saying this to state clearly that there is a problem of clarity over here, just because the norms that we've developed for these different kinds of speech, they don't necessarily converge neatly. So there's that. And then the last one, of course, you've heard quite a lot about this, so I'm not going to go into it in detail, is where do these threads go, right? One is issues of journalism. So you have algorithmic moderation, you have paid content showing up on top, and it can affect local journalism. But again, if you're sensitive to political contexts, in countries in which the mass media is increasingly damaged, certain kinds of information, certain kinds of independent journalism only come from people posting their stories on web-based platforms because no mass media outlet will carry it. And that kind of information, again, is information that is lost to the world depending on how algorithms treat it. And the final is that in regions of in areas in which there is conflict or there's a particular kind of dispute brewing, you also have the problem of a temporary censorship of speech. But if the speech is not restored within a particular window of time, its salience to the debate means that basically a moment in a historic opportunity is lost. So we had this happening with the Me Too movement in India, and luckily it was fixed very fast, where this young woman raised a lot of controversial issues, and she put up one of the the naming and shaming lists. It was subject to a lot of political debate in India. Her account ended up being disabled. Luckily, she was able to access the policy team of the company through a back channel, and it was restored within the hour. But the question is, what if it wasn't? That debate was one of the most important conversations happening in the country at the time. So that's context for you. I like that somebody pointed out this morning, I believe it was Ellery, that although governments in the world are taking note of the role that platforms are playing, what we end up facing is the issue of second-order regulation. You have the regulation coming out of the EU or the US, and it has effects in other parts of the world because the platforms are going to follow this regulation, and the effects may be good, they may be bad, but the question is, are they being considered at the point of conceiving of the regulation? And that, again, is a problem from the rest of the world, right? Now, what is the value of all of us getting into this? So for the longest time, I think that there's been a bit of a hands-off approach from people that are interested in civil liberties, because we've conflated platforms with a lot of power over information with startups. We've been using the same language to talk about, how will this company make it if we have all these onerous regulations on them, and Facebook and Google and Twitter and YouTube, and they're not the same. So, so far, and I've been guilty of this for a few years as well, we haven't really talked about hard guidelines for the companies. We've only talked of the companies in contexts in which they're succumbing to government pressure. We haven't asked what mistakes they're making. Is there a margin of choice over here? Perhaps they don't have bad intentions, but is it also that they're not facing up to who they are and to the role that they play in the world? And I think the problem there is that we've never recognized that there's a difference in scale, that the influence on the information sphere needs to be acknowledged. And I think we finally reached a stage where that's happening. The UN Special Rapporteur for Freedom of Expression is also looking into these questions. And so why is this a problem? So where this has led us really is, initially the conversation was about intermediary liability, about the ways in which governments are going to pressurize gatekeepers to violate the rights of people. But if you track litigation in India, for example, I think we're reaching a place where, perhaps for reasons of government pressure, but also partially by choice, platforms are beginning to negotiate with governments and are consenting to the setting up of what looks suspiciously like an internet referral unit. So we have a case on revenge porn in India. It's basically, so the category of speech itself is unquestionably harmful. It's gang rape. But the device that the government and the platforms have come up with in they were both a part of a committee, and they basically come up with a device in which the government is going to come up with a set of keywords and content that the companies are going to take down, and it's all a black box with no accountability really. There's no question of notification, well, not to users anyway. There's no, as far as I can see, no independent assessment of whether there's going to be overreach. And it does not appear from the parts of the report that have been released that any questions have been asked about whether this device might be extended to other kinds of content, like defamation, that are illegal but don't necessarily warrant such a radical solution. So, when I read orders about reports like this, my question immediately is, why are the platforms cooperating with this? They know all the people that work on civil liberties and freedom of expression in the country, and yet none of us were invited to testify in front of the committee. None of us were a part of the committee, and we weren't warned that this is going to happen. And so it leads me to the question of, do we really want to be so hands-off that at the stage of crisis, the negotiation is happening between the companies and the state, because it doesn't seem like what emerges from that negotiation is beneficial in the least to civil liberties. So that's problem number 2. And so finally, having offered you this very sunny perspective, I just want to say that that there are concrete questions on which we can do better, and I want to give you some examples. Through this time, I don't believe that I've ever heard any of the actors in this space say that freedom of expression or privacy are not values that they believe in. The problem has always lain in the actual way in which they regulated, the space that is given for decision making, many of the things that Rebecca works on and points out. And so to give you examples of things that are going wrong, one is that anonymity, right? Everybody agrees that anonymity has its benefits. People acknowledge that the lack of anonymity also has its benefits for policing, but oftentimes, we've got something like the real name policy being offered as a solution to other problems, and I feel like I don't want to dispute the fact that it is a solution, but I think what would be useful is a conversation about the cost and benefit of using this, right? What are we losing? What are we gaining? And on the whole, is this something that is beneficial to civil liberty? So that's one example. 2 is that I'm actually very happy to see that all the platforms are moving towards a notification and an appeals process. That's really encouraging. It's something that a lot of people have been asking for. But what happens at the stage of appeal, right? So if we're being granular again, the question would be, at the stage of appeal, who looks at the speech and at the decision being made, and who evaluates whether this is something that is in line with international human rights norms? I would ask whether we're thinking of a set of experts that understand freedom of expression and the manner in which it can be violated, and whether we've offered them the resources to engage properly with each question and offer their advice in a thoughtful manner. I would say the same of expertise. Again, it's a very encouraging trend that all the platforms are engaging with experts. But as someone that is often in a position in which I'm asked, which way do you think we should go? What should we do to deal with these questions? It's definitely a good thing that we're being asked, but I also feel like if we want to get the best advice out of experts, foundations and others need to come together and make sure that the experts are in a position to read and to apply their mind to issues. So that's really it. I think I've taken up quite a lot of time. I just want to say that it's a pleasure to be in a room full of people that are working on this question, and I look forward to what is to come.
Thank you, Chinmay. What you have to say always needs to be listened to. And everything you just said, I think there's a lot of wisdom there. And this whole question, of who's making the decisions when companies have appeals processes, and what support is there to bring in people from outside the companies is a very important one. So we can perhaps pick up on that as we go along. I'm going to move next to Yaman Akdeniz. And I think you have a PowerPoint, so hopefully whoever controls such things can bring that up. And Turkey, of course, is a very challenging place for freedom of expression these days. It's one of the countries where companies receive a very large amount of government demands to take down content, and Turkey is also one of the biggest jailers of journalists at the moment. So we look forward to hearing what you have to say.
Thank you, Rebecca. Turkey has a long tradition and history with censorship in general. And since 2007, that extends also to the internet. And since July 2016, we're in state of emergency, and the state of emergency continues. Over 140 newspapers, TV channels, in total radio channels, publishing houses have been closed down in Turkey since July 2016. And now we have over 175,000 websites, unique websites, being blocked from Turkey, including Wikipedia, since the 29th of April 2017. It will be in a few days, just 1 year. And in the past, Turkey, of course, has blocked access to Twitter and YouTube. YouTube was blocked for over 2.5 years between 2008 and 2010, which we took to the European Court of Human Rights, and it decided on our favor in December 2015, finding a violation of Article 10. And also, in addition to that, over 100,000 unique URLs are also blocked from Turkey. These include news items, social media content, and plus just over 60,000 individual content have been removed, predominantly by social media platform operators since 2014 in total. So this is the setup, and today there was the final court hearing of the Cumhuriyet trial. Cumhuriyet is a well-known opposition newspaper, and almost all the journalists who were on trial received extended penalties for terrorism-related charges. So this brings me into the fundamental importance of the availability of social media platforms in Turkey, because there's not any or much independent media left in Turkey. So if you live in Turkey, you're forced or compelled to use Twitter and Facebook predominantly, because otherwise you wouldn't understand what's going on in the country. But I want to show you now, by experience, what's happening with regards to Twitter and Facebook. Rebecca knows probably this better than anyone here, but majority of the tweets removed by Twitter in the world in his transparency reports covering all the periods. Out of 14,725 tweets, 9,552 of them removed from Turkey. So every year Turkey comes up high, or until recently, I can say, because you will see that now there's a sharp decrease in the amount of tweets removed from Turkey by Twitter since end of 2016, but also globally the numbers are going down. My initial thought was that this was a good thing, because Twitter is resisting in removing tweets globally, and especially in relation to Turkey. But my research, and this is a continuing research, shows that this is not necessarily the case, because what Twitter does, very important in terms of transparency, when it receives a court decision, this is an example, you can see that several tweets are named on that court order. It's not a recent decision. It doesn't explain why the tweets should be blocked or removed. Rüstem Batum is a well-known former journalist and author and a dissident who lives in the United States now because of his political views, is named in that tweet. So what happens is that Twitter forwards that court decision as well as the tweet to the user, to Mr. Batum, and says that there's a court order in relation to one of your tweets, and it says if you wish to remove it, you can remove it. but it's in almost threatening words. And it says you could challenge that decision and let us know, but feel free to remove it. So what happens is that this has become a common activity. So as soon as the users receive these kind of email messages from Twitter, majority of the users that alert us remove these tweets. So it's not Twitter, but it's the users removing the tweets. This is one way of reducing the number of tweets you globally remove from your system. The second thing they do, this is again Mr. Batum, one of his tweets was reported. We're not clear whether there's a court order in relation to this tweet or other users reported it, but this has become a constant activity. As soon as Mr. Batum logs into Twitter, he sees this in front of him with the delete option. Unless he deletes the tweet, he cannot use his Twitter account. So Twitter compels the user to delete the tweet. And if he doesn't delete the tweet, he can't use the, and when you look at the, if you go back and look at the statistics I showed you, that's one of the reasons why the number of tweets removed from the Twitter platform is going down. And another problem is that Twitter never tells you the number of requests to remove or delete tweets. It only tells you the number of accounts which were reported. And I can also tell you that over 800 Twitter accounts are currently blocked from Turkey. So this is a problem. There's problem of transparency, which has been mentioned, but there's the problem of Twitter compelling its users to remove the tweets. Rather than, for example, Twitter can, if it chooses to do so, remove this tweet. And as you know, they remove it themselves. And with regards to Facebook, I think Mr. Stern should see these, some of these tweet slides that I'm going to show. We recently published a report for English PAN called Turkey, Freedom of Expression in Jeopardy. And I was in London presenting this report. And then I was interviewed with by Voice of America. And this was, the interview itself was published on Voice of America's Facebook pages. And the interview is entitled, "It is Even Difficult to Be a Citizen with Opposing Views." That was, I was explaining what's happening in Turkey and how it is difficult to be anyone with opposing views. There were over 200 comments under this particular video, and you can see some of them. And majority of these comments were about myself. So because I was coming here, I wanted to test the system. It took me almost 2 hours to report 50 of the worst of these comments to Facebook. And I did that from my phone because you can't do it from your web browser, apparently. So if you don't have a phone with Facebook enabled, there's no possibility of reporting these comments individually. That's another interesting thing. So first 24 hours, I haven't heard anything from the Facebook reporting. And majority of the reportings I made were for harassment, for hate speech, and for, there's another category, it's harassment, threats, for threats. And some of the comments that I reported included all the three categories. Then the reports started to come in, and it was like raining, because like within a few minutes, 10 of them were reported. And within less than an hour, I received all the reports from Facebook. And out of the 50, apparently 48 of them did not breach the community standards of Facebook. I'll show you some of these. Some of them call me traitor, terrorist. Some of them say that I could be all kinds of shit, but I can't be a traitor. Some of them called me son of a bitch. Some of them they tell their desire to rape me, my mother and my wife. But none of these were apparently in breach of the community standards set by Facebook. And so I wonder if it was artificial intelligence, then it didn't have any intelligence. And if it was a human being with Turkish knowledge, then that was apparently one-sided. And the irony of that, I'm not easily offended, but this was targeted harassment. And if you use any of these words describing a government MP or a politician or the president of Turkey, they would be immediately removed. Secondly, I wouldn't be here. I would be in jail, arrested. And so this is obviously problematic. This is the Facebook community guidelines. I'm not going to read them. There's no point for that. But the problem is that Twitter, together with Facebook, have become the long arm of the Turkish law enforcement machinery. And this is part of a larger tilt towards censorship in Turkey. And social media companies like Twitter should not, or Facebook should not be aiding governments that exert political pressure on their citizens. Their only interest with regards to Turkey is to remain unblocked, because there's the possibility that if they don't obey these requests, they will be blocked completely from Turkey. I can understand the hesitation, but on the other hand, look, Wikipedia. Wikipedia is still resisting the Turkish authorities, and it is fighting that through the courts. But Facebook and Twitter does not take any of these blocking requests to the Constitutional Court, or they can take them to the European Court of Human Rights. So I think there's more to transparency-related problems with regards to these social media platforms. And also, I mean, what to do next? We're looking into public interest organizations in the US, or even law clinics in universities, because we now want to take action, legal action, with regards to Twitter as well as Facebook, because of their dubious policies, because of their breach of fundamental human rights in the United States. I know that they will be difficult cases, but we want to, whoever is willing to do so, I'm happy to talk them further about taking legal action against these companies to protect their right to freedom of expression. Thank you very much.
Thank you. I hope there's some journalists in the room that are going to do a lot more reporting about these particular cases, or we can try and convince some journalists to, I mean, this should be in the front of the New York Times, I would think, but in any case, yeah, yeah. There's a lot of reporting about Facebook. That's true, but I think just the story that you just told, I think should be understood more widely. So hopefully it will be. So we're going to move next to Latin America with Ona Flores, yeah, I'll just hand it right over to you from your regional perspective. What are the key issues?
Thank you, Rebecca, and I just briefly want to thank you again, Agnes, for inviting me again to this conference, and Hallie for organizing, and the panel, and you guys. It's always, I learn so much every time I come here, so thank you. So in our part of the world, Latin America has been also engaged in discussions about freedom of expression online and the role private entities play mostly as the concept of facilitators, enablers of the right to freedom of expression. And the last year was a year definitely that we had to, in the office, and we saw these discussions in Congress, in the courts throughout Latin America, grappling with issues of hate speech, then fake news, right to be forgotten, protection of reputation and privacy. And what the office I work with, and the rapporteur is here, and the former rapporteur are also here present, and they have contributed to this discussion by issue thematic reports, basically. As you are aware, that they sort of are form of they also talk or form dialogue with the thematic reports that the UN Special Rapporteur, there's in other projects that we work together. So in 2017, last year, we issued a major new thematic report on internet and freedom of expression online. And that report, for the first time, dealt with a little bit with the question of what the role of private entities in the private sector have. I don't think I'm going to say much new. I just want you to know that this is part of the legal framework under how the Inter-American Commission, together with the Office of Special Rapporteur, understand or interpret Article 13 of the American Convention on Human Rights. And what it was a big deal was the Commission talking about private entities in the private sector and them having responsibilities of human rights. That's not something that the Commission has yet to be actually addressed. So this is one of the first time the Commission's in a major report deals with the issue. So the report includes I'm just going to summarize the basic responsibilities or content of these obligations. And they have been talked about throughout the morning, so I'm not going to point it to. They reaffirm high-level commitment. The private actors should have a high-level commitment for freedom of expression, and those should be followed up with concrete measures of how to implement it. The Inter-American Commission recognized that the application of terms of service should respect freedom of expression due process, and that's established in the report very clearly. And then when they set terms of service, they should be established by predetermined policies based on objectively justified criteria, respect minimum due process guarantees. And for that, the report takes into account joint declarations by previous special rapporteurs. There should be a system for monitoring the human rights impact of their activities of the private entities and better human rights impact assessments. Redress mechanisms should be put in place, and especially the report puts a lot of focus on transparency. Transparency on the terms of service, policies, any operating procedures and practices which directly affect the public, and those should be really accessible, which touches upon the issue that was raised in the morning. They should be in the language of the community that is involved and not just in English. And citing the joint declaration of last year, the report also touches upon or hints of the idea of transparency also on any automated processes. Those should be in place. And then there's questions of an invitation to continue thinking in collaboration with other actors to seek solution for these issues. So this is basically what the report spells out. There's other questions that are not answered. I mean, what is the role of a company when, and it's very relevant for Latin America, when it gets a court order that is really inconsistent with freedom of expression and standards. That has yet to be addressed, but I know it was part of the important discussions. And also it doesn't spell out more concrete measures, it's just basic. But just to tell you that this is also part of the inter-American legal understanding now, thanks to this report. The report also examines as well, when it comes to government, what is the role and how do they complement each other? In this, it doesn't go too far, but expresses basic principles. Any request that the states make to the private sector to remove or monitor content must meet the three-part test of its due process requirements. So that's pretty spelled out in the report. The same, it adopts its intermediate liability regime conditional to failing to comply in a court order. That's pretty spelled out throughout the report for different kinds of issues. And it talks about how it's the commission and the special rapporteur are very concerned about the possibility of delegating content regulation and monitoring to the private, entities like Facebook. And it reminds us that even though it doesn't say it clearly, I would interpret it as favoring any decision of removing content always with a court order and not creating systems that would put the pressure or the incentive to censor more to those companies. And hopefully that's something that will be spelled out in other declarations and statements. And then the sense of any law, policy, or regulation should be adopted with meaningful consultation and in a manner that is transparent. So those are the obligations vis-a-vis private sector that are spelled out in the report. Now, this is recent. This was issued in April 2017, and the office is working together with other initiatives to try to make governments throughout Latin America and the region in general to know about these standards, understand them, and actually implement it. But the reality is many states are currently promoting legislation that would severely restrict the publication and dissemination of information on social networks. I just want to talk about 3 examples of draft proposed laws that are very concerning to us, and they really are not trying. What we saw, these are not laws because of the particular context in the countries that are being adopted or proposed to be adopted. They were not laws or legislation or regulation that was trying to really grapple and put up a solution for hate speech or fake news, but we're really trying to continue censoring content. The first one is before the former president of Ecuador left office, he sent to Congress a bill that the idea was to require internet service providers to remove illegal content within 24 hours of actually noticing that illegal content. And that's for manifestly illegal content. And then 70 hours for once they have received a complaint. The problem with that law, as that was the opinion of the Office of Special Rapporteur, was that they was based on overly broad and extremely vague provisions in the criminal code. So that was going to be extremely difficult for anybody in this company to figure out what hate speech or defamation or invasions to privacy would mean. And with no guarantees of due process in any of those in the law. Then months later, Venezuela took it to another level, and this time it adopted a hate speech law that, with a very broad definition of what hate speech is, and that was adopted within the context of many, as you may be aware or not, of a social protest and that lasted for a couple of months. And the requirement there here is 6 hours of removal of content after publication with no court order or any other due process guarantee. And currently we're actually in the Honduras Congress is debating as sort of a mix of these 2 laws. The Ecuadorian is very similar in terms to the Ecuadorian with the severity and of the Venezuelan. I forgot to mention that if these companies do not do that, they will be blocked. That's sort of the sanction. They will be blocked. So this is the environment where we're seeing regulation of content and of private sector companies and how do they regulate and address issues of hate speech and fake news. And we are very concerned about this trend. On a positive side, we're seeing a bill that is being discussed in the Argentinian Congress that will implement the standards that I mentioned before, and that's sort of sees a more positive way to address this. But that's all.
Thank you. So I'm going to turn next to Peter. And then, Chris, I'll come to you sort of as our closer, if that's okay, to sort of wrap it up a bit. But I think the time has come to turn to Facebook and hear what you have to say in response to some of the things we've heard. But also, you know, to kind of come back to where Bertrand started, in terms of, you know, how we forge a path forward, right? If we assume that we all kind of share the same values, how do we help Facebook figure out how to respond to conflicting government demands? How do we work with Facebook to do better in all the ways that we've heard that people would like Facebook to do better? I guess, how do you see kind of the role and sometimes the clash between, you know, what some of us sometimes call Facebookistan and sort of the private governance that you've developed, and how closed is it? I mean, we heard one idea where, you know, it's been suggested that Facebook should be bringing in more people to help make, you know, not just staff who are being hired to make determinations about appeals, but should there be outside counsel? Should there be stakeholder representation to help formulate your policies, to work to push back against governments in different ways, to help also anticipate where the risks are? One of the critiques that many of us have had, and including myself sometimes, is that the risk assessment hasn't been broad enough in terms of what the harms could potentially be, and so is it possible to kind of bring in more stakeholders to work more directly on these problems rather than kind of wait for them to play out?
Sure. Okay. Thanks very much, Rebecca, and thanks very much, everybody. I'm really delighted to be able to be here today. So I'm a lawyer by training. I joined Facebook about 4 years ago. My background was in commercial law with an emphasis on business and human rights, and I also did a bunch of human rights litigation, including one case beginning 20 years ago, if I'm not mistaken, with Sandy Colliver, who's here in the audience today. It's fun to see her. So I'm now part of the product policy team, which is the team that makes the rules for what people can share on Facebook, our community standards, as well as ads policies. And that's a big responsibility. That is definitely something that we need to step up to make sure that people understand what we do and the policy rationale for what we do, because we have some difficult lines to draw and people are entitled to know the thinking that goes into that. Over time, my role has come to focus more on stakeholder engagement. So I lead a team that is in charge of stakeholder engagement with respect to our product policies. So when we are thinking about making a change to the community standards, we will go out and talk to experts and NGOs, groups that we feel can give us valuable perspective on these issues, groups that want to be heard, want to have their opinions factored in. And this is something that we've been building up. It's incredibly important to us. It's integral to the process. So that's why I'm here, and that's why I want to talk to people. And I think that I've learned a bunch of things today, but probably the biggest takeaway for me is this very interesting question of the ask, and how do stakeholders respond when we sit down and say, what would you like us to do? Which is sort of, as we see it, you know, we're being open, we're being vulnerable. This is really the dialogue that we would like to have. I can see, however, and I have a better understanding of it having been through the sessions today, that that's not necessarily the best way to set things up for stakeholders, that there needs to be, in many cases, a more solid base of common understanding, of knowledge, so that our stakeholders are better able to respond to that invitation that we're putting out. We want it to be meaningful, we want it to be substantive, we want it to result in real changes. And so this is something we're going to go back and talk about. And I think it goes to the issue of transparency, which is something that we've been trying to make strides on, and that I want to say a quick word about. Freedom of expression is absolutely fundamental to what we do. It's a core value for us. We often talk about the importance of voice. It's incredibly important to us to give people throughout the world a voice to talk about what matters to them. Sometimes it's provocative, controversial ideas. We know that that's the case. We want there to be room for that on the platform. So that is absolutely critical to us. At the same time, though, we also recognize that safety is fundamental, and people need to feel that they're going to be protected when they come to the platform. And I think this goes to the countervailing value that a number of speakers have been talking about today, which is the right, if you want to put it in these terms, not to be intimidated or not to be kept out of the discussion. And we take that very seriously indeed. And it's something that we worry about a lot in all parts of the world, but particularly perhaps in areas that are just coming online, where you have, for example, women who are afraid to be on the platform because they don't want their pictures to be misused. Chinmay, that's a point that you were making. We've developed some tools so that, for example, people can make it impossible to screenshot a profile picture, kind of a watermarking system. This is an example of the type of way that we've tried to respond to that. There are other ways, and it's also an area where we need to continue to do better. So voice, safety, and then the last thing I think I'd point to is fairness. We want to create a system that people regard as legitimate and fundamentally fair, even if in any given instance they don't agree with the outcome. I think this is one of the learnings from the work that we've done with political scientists and procedural justice experts who've told us that you got to get people to believe in the system, because otherwise you're not going to win them over. And so we're taking that to heart and trying to create systems where people can be heard. It is a real challenge with the user base that we have of more than 2 billion people. And I was having a discussion with somebody earlier today, and you think of sort of a traditional business and human rights setting where you've got a mine that's going into a small town, and you can go out and talk to the people in the village to understand their concerns, to try and address them. That is a different order challenge for us with 2 billion people, and we're trying to figure out ways to address that. But that's something that we're working on. So the ways that we have tried to navigate these various policy challenges to fulfill our mission of building community and bringing the world closer together are incorporated into our community standards, which you may have seen online. Actually, just yesterday, it was a really big step for us. We brought out a new version, a much more detailed version of our community standards. It went from something that would have been about 5 pages if you printed it out to maybe 25 or 30. We've now disclosed the internal standards that our content reviewers use when they process user reports. And we're hopeful that this additional disclosure will go to that point of creating better dialogue, will enable people to talk to us on a more informed basis so we can have better conversations and come to better results. Yaman, I'm very sorry that you had a bad experience on the platform. My hope would be that additional steps of disclosure, like making these rules public, additional things that we can do to try and explain the nature of our policies, would help to bring some of that into focus. And if we've made a mistake, then we would take steps to correct that. We definitely make mistakes, which is something that goes along with the large user base, the number of reports that we have. But where we make mistakes, we want to acknowledge them and fix them. So those are some of the steps that we've been taking towards improving the interaction with users in the community. We've also yesterday introduced an appeal mechanism, which would have been another way that we could have gotten to a better result, perhaps. Because in the past, we've allowed users to appeal the removal of groups and pages, certain large objects like that, but you couldn't appeal the takedown of an individual post, video, or photo. As of yesterday, you can, if it hits on our policies for hate speech, nudity, pornography, or graphic violence. And over time, we're going to be adding other content areas as well. So those are some of the steps that we're taking. Now, when it comes to password protection is tough. Let me just address some of the issues that we've been dealing with when it comes to our relations with governments, because that's been a big theme today too. In some areas, we think that partnership and working together with multiple stakeholders, including governments, is the way to go, is essential. You think, for example, of counterterrorism. We have a lot to learn from governments. We want them to understand how we are handling these important issues. We're under pressure, they're under pressure. Of course, we also talk to civil liberties groups to understand their concerns as well, but we work with multiple partners. That said, in many cases, we are not aligned with governments. If a piece of content doesn't violate our community standards, we fundamentally don't want to take it down. We want it to be on the platform. But we are respectful of local law, and we will respond to process and court orders from individual countries when we receive it. And if we're convinced that the order is narrowly drawn and solid and it passes legal muster, then we'll block the content in that country while leaving it up for the rest of the world. So that's by now a fairly well-developed process, the results of which are published regularly in our transparency report. And I think that's kind of the starting point for much of the discussion that we might have around the issues that Bertrand has raised. So I think I'll leave it there. I have some other thoughts, but let me pass it on to the next speaker, and I hope that's been helpful.
Thanks, Peter. I have sort of one follow-up that perhaps you can address, but that might also Chris and then the other panelists can also address, which has to do with precisely what you were talking about at the end about sort of when a government request is legally binding and sort of kosher according to domestic law, you take it down. But one of the sort of complaints we hear is that more and more governments are passing more and more laws that make more and more speech illegal. And so therefore there's more and more takedowns. And that while it's good that you're being transparent, that there's transparency about the takedowns so that we know they're happening, we still haven't addressed the fundamental problem that more and more speech is being criminalized in more and more places, and an increasing amount of speech is coming down, and you're being compelled to do so because it's a lawful order. So that's kind of the level of problem that RDR doesn't really help solve. We're pushing you to be transparent about it, which is good, but that now what do we do about kind of the growth of bad law that leads to more takedowns that, you're then having to be more transparent about, but is still resulting in more speech going down, and how we deal with that. But I think that might help to segue a little bit to Chris as well. So if you want to either respond to it now, or if you want to think about it and respond to it after Chris talks, you can do either one.
Yeah, I'll let Chris go ahead. I don't have a solution for that. So, but I agree with the observation.
Well, so that does segue into a couple of the things I wanted to speak about. I'm Chris Bavitz. I'm on the faculty at Harvard Law School and run our Cyber Law Clinic, which is our tech law and policy clinical program. I'm also based at the Berkman Klein Center and oversee our Lumen project, which used to be known as Chilling Effects, which some of you may have used in the past, and can talk a little bit about some things we're doing there, along with other research initiatives at the center. And I guess I'll just say briefly, I think that transparency is vital here in so many respects, and I actually think the environment we're in pushes toward more transparency in a lot of ways. I think the presentation this morning about the 2018 report from Ranking Digital Rights was fantastic. I loved the little preview of possible issues you might be thinking about in 2019 about algorithmic transparency and that sort of thing. I would love to talk more to you about that. I think that's vital. I think the transparency has sort of 3 layers to it. I think there's transparency about the standards that are being applied to moderate content, which again, I think this move Facebook made this week is terrific in that regard. I think there's transparency around due process, what standards are being applied when someone sends a takedown notice, and is there a right to a counter notice? I always hate to use our DMCA in the US as a standard for anything, but one of the things that it does have going for it, Section 512 of our Copyright Act, is that it bakes in this back and forth process where you can send a notice, I can counter notice, there are rights and remedies for each of us if it turns out either the person who sent the notice or the person on the receiving end of the notice was incorrect about their claim. And in the end, the DMCA regime leaves the content up if no one decides to do something about it. So in some ways, it puts a thumb on the scale in favor of leaving content out there, which I think is generally a good thing. I think we're seeing transparency happen in a lot of respects. I mentioned, obviously, the Ranking Digital Rights stuff outside companies or agencies or organizations doing risk assessments or impact assessments. GNI came up earlier, another organization that I think does a lot of these human rights impact assessments for the companies that are members of GNI. And the companies themselves are doing a lot of transparency reporting. If we were having this conversation just a few years ago, that wouldn't have been the case, but we've seen extraordinary developments in the last few years of the companies voluntarily coming to the table to do at least aggregate level transparency reporting. One of the things that we're seeing in our Lumen project, and for those who don't know, at Lumen we have partnerships in place with Twitter and Google and a lot of the platforms to get not only aggregate data from them about takedown requests and responses to takedown requests, but actual notice level data. So when someone sends a takedown notice to Google saying remove this link from search, either because it's an infringing Coldplay MP3 or because it's a piece of defamatory content that I'm alleging impacts my rights, Google does what it's going to do with respect to that notice and then sends the notice to us. You can go to lumendatabase.org and see a lot of the notices there. And one of the benefits you get by having that notice by notice data is you do start to see some of these trends that I think are in some ways a product of having to do this at scale, as Rebecca said. Eugene Volok's been publishing some really interesting stuff in the last couple of months coming out of the Lumen database, taking a look at notices and finding examples, these are US-based examples for the most part, of forged court orders. I don't know a more delicate way to put it than that. I mean, absolutely fake court orders with a fake caption from a fake court and a fake notary stamp at the bottom on something that to say, yes, in the Smith v. Jones case, it is hereby ruled that this content is defamatory and that all links thereto should be removed. And again, Google processes that as a takedown notice. So this isn't even an example of what Rebecca's talking about with respect to new laws. This is simply an inability, understandable to some extent, given the massive scale, but an inability to check every one of these notices that come in. If you're the victim of some critical speech online, you might hire someone to do this on your behalf, conclude that you can manufacture a court order or submit something that's forged or fraudulent to Google, get it out of search, not get it off the original platform where the content sits, but at least get it out of search, and by doing so, get a lot of the way there in terms of fixing your reputation or whatever you think you're doing by doing this. I should say there have been some criminal prosecutions that have come out of this, so I don't encourage you to do that. But it's a problem that's
You can go to jail.
that's happening. You can go to jail, exactly. One other thing I'll just note, which came up a lot throughout the day, and I think it came up less so here, is that I think, and it goes back really to one of the first questions that was asked of Rebecca during the first panel this morning, which was, let's say you have GNI doing its thing, Ranking Digital Rights is doing its thing, transparency reporting, we're releasing the community standards, we have, all of those little bars from the Ranking Digital Rights report are long, and everyone is fully compliant with all of the standards that we've laid out for them. That does not get to the problem of whether there is false information on these platforms. It doesn't deal with the fact that Wikipedia may say something incorrect about the Armenian genocide or about Hillary Clinton's emails or about climate change or vaccines or about the Rohingya. And I think that is a really, really hard problem to grok. I think that we are in a, I don't want to say a good place, but we have good processes in place to deal with criminal conduct, threats, intellectual property violations, truly defamatory content where a judge has adjudicated or a jury has adjudicated the content to be violative of the law. I think that the misinformation, disinformation, fake news problem is really, really hard in this context. So that's my pessimistic note I'll end on. But
we have, I know that we're mandated to finish on time, so we have, like 18 minutes or something. But I want to press the panel a little bit, and if people in the room kind of want to add to this specifically, maybe I'll sort of make an appeal to the extent, as we have participation in the room, maybe let's focus on a particular topic rather than just bring up whatever questions people have to mind. But is the question of if we had, another hour or so to come up with sort of the document where we say, here's what we want companies to do next, and here's what we want governments to do next in order to get us further towards wherever it is we want to be versus where we are now. And let's say where we want to be is that you don't have activists, having their, being intimidated into taking down their tweets, and that you have genuine hate speech and so on being taken off platforms, but journalism, activism is staying up, and women are not subject to threats, and that may be a utopia, but if we want to get closer to that, where speech is respected and protected, but there's governance of harmful behavior, what steps do we need companies to move towards? What steps do we need governments to move towards? What, in terms of other actors, what do we need to do to move in that direction? So does anybody want to start?
First of all, I want to say that, I double-checked. Facebook doesn't give me an option to appeal against this decision, so I can't appeal. It just gives me some option to block the person who commented, but nothing else. So there's no way I can appeal against people.
Right, that just launched yesterday. So going forward, you'll be able to. You're right.
What am I going to do about the 48 comments or all the comments that I showed you? I can't appeal or challenge them again, so it doesn't resolve my problem. So
Will he be able to, Peter, will he be able to go and challenge them later, sort of retroactively, or just in the future when he gets new threats?
I'm honestly not sure about that. Let me check on that.
Well, I'm sure about it. You can check my phone.
Yeah.
So building on that, I think we reached a point that certain types of regulation of these social media platforms is inevitable. Yeah. I'm not talking about regulating their content or anything, but at least for redress mechanisms, these kind of rules. I don't think that, we're talking about a platform with 2 billion people, and we're still saying in quotation marks a private platform. No, in my view, this is no longer a private platform. It has become the opposite. These platforms are public platforms, and that's why I think certain regulation is necessary, at least in terms of defining what transparency means, because I'm a great user of the Lumen database. Twitter, for example, puts all the decisions from Turkey there, but there's no Facebook there, so I can't see the decisions. I have to obtain them in another way. So for transparency rules as well as redress mechanisms, because I don't think Facebook's redress mechanism works. Twitter is moved into another direction as well. So, and there needs to be some sort of rules for the users. I understand that somebody should be able to challenge if their content is removed or their account is banned, but on the other hand, somebody like me should be able to challenge some of these decisions before going to court and report them. So thank you.
So Bertrand, I know, is anxious to say something, but this also relates to some conversations that have been happening in the internet and jurisdiction meetings. Is, can we bring a set of stakeholders together to come up with standards for redress, for grievance and remedy. Is that perhaps a major priority? Bertrand, do you want to tackle that, and anybody else? And
Yeah, as a matter of fact, there was a direct follow-up to what I was saying before, and I'm very happy about this this panel and this discussion, because this is exactly the direction we need to go in. For those who are interested, we had this conference in Ottawa, the second Global Internet and Jurisdiction Conference, and the purpose was precisely on the different tracks, and one is on content, to identify sub-elements and sub-questions that can structure the discussion on a concrete and operational basis. So I have a few copies of that, of the outcome document, if you want to ask me afterwards, or I'll give you the link. I will not make the list, but this is exactly what we will be doing as the Secretariat between now and the next conference that will take place in Berlin in June next year. And what we're doing at the moment in conferences like this one and others is to identify the topics that are ripe, the things that are concrete, where everybody knows we need to find a solution. We all know that solutions will only come if two things are present. One, if there is a commitment of the actors to actually work together to find a solution, because otherwise nothing is going to happen. And the second thing is that obviously people are going to be really willing to work on finding a solution if there is sufficient pressure. It can be public pressure, it can be governmental pressure, it can be user pressure, it can be business pressure. I think the pressure is there. And issues such as what are the redress mechanisms, what are the notifications. I like very much the comment regarding the DMCA, although there is a debate on whether the DMCA, which is a counter notice after the decision, is the appropriate one. Maybe there are cases where the notification should be done to the user immediately before a decision is taken, because there's no real matter of urgency, whereas on others there is a matter of urgency and the takedown can be made and then the counter notice come afterwards. In a certain way, what you described, Yilmaz, regarding Twitter notifying the user, until, and this is purely personal, but until you mentioned that the user had to delete to be using his account, I was relatively comfortable with the process, because that's exactly what we want to put in place as a loop. And just a final element in that regard, without getting into the details. We all wish we would have a court decision for every single takedown. Yes, don't have to ask you, raise your hand. Everybody would love that. Two problems. One, volume. And second, which court, which enforceability across borders.
Yeah.
So I don't want to get into the details. Just this question of redress is fundamental. I want to highlight another one and maybe throw as an idea to test the waters. Narendra was highlighting the potential chain that starts with very minor hate speech and goes up to genocide. I am, on a personal basis, haunted by the history of the Rwandan genocide. And you all remember that most of the calls were by Radio Milcolin that said, let's go kill the cockroaches. Going to the hyper-local thing, how do you know that this is a special meaning? And I just want to float the idea. Aren't we confronted with a situation where we need to try to get a cooperation mechanism? It's not regulation. A cooperation mechanism that would be the equivalent of a rapid response system that allows the easy and rapid detection of things that are going to emerge, allow the connection channels between the local authorities, the users, the civil society, the civil rights entities, and the companies to be able to act as quickly and as proportionately as possible. Because the earlier you act, the more proportionate you become. And I don't think 911 at the global level for circulation of information with the channels, it's the red phone between the Soviet Union and the United States, I don't know.
Yeah.
But something, you see,
Yeah, well,
just as
which
an
brings me,
idea.
I know Chinmay wants to talk, and Chinmay, you know, I mean, that doesn't that sound like it also requires a lot of trust between the sort of civil society and the authorities and so on, and actually like feel that they're not working at cross purposes to one another.
It does. And to paint a dark picture, that a lot of the times people looking to kill the cockroaches are the government. And so I don't know that you want to listen to the local authorities all of the time, but the challenge that you present is a very real one. It's something that bothers me also. I feel like we might have seen the beginnings of a step towards this, which is I'd done an essay on this based on our harmful speech work, and the question that I've been asking is, if content is going viral, even if it is a completely harmless photograph, the platform is able to ID that it's going viral, and it is possible for people to tell journalists, civil society, people that are watching a region, that this is a conflict region and it is prone to violence. If you put those two pieces of information together, I think it's possible for a platform to realize that there's something wrong when content is going viral and violence is escalating. But for that, we need enough trust for that data is being shared with people that are able to make this determination. I think that Facebook is to be congratulated in this regard because they finally, they've just announced that they're going to start data sharing with independent experts. It's just the beginning. I don't know where it's going to go, but I do hope that it's in this direction. To my mind, that's the only way that we get to this place. In this regard, I do, I think that this government platform tension is an important problem to navigate. And from that point of view, I don't agree with the system in which all court orders are followed. I appreciate that it's hard for platforms to decide or to make that decision all of the time, but I think that there are contexts in which it's very clear that a court order is in violation of international human rights standards. And what I would like to see is for platforms to commit to disregarding those orders when that should happen. From that point of view, what would I like to see from governments? I know that this is an unrealistic ask from governments that don't subscribe to international human rights norms or to the rules of democracy. But I think that it's possible for the countries that do to use second-order regulation to ensure human rights around the world. Example, the US has this law that prevents the platforms from sharing personal data of people with governments on their just say so, right? So if the Indian government wants data about a user of Facebook, it has to go through the MLAT system. The Department of Justice vets the request. Now, this is something that the governments have been renegotiating with the US government, saying amend your law, enter into bilateral treaties. And I like to point out that this is a place in which the US government has the option to insist that human rights norms be followed. And if they back off and say, yeah, sorry, it's your problem, you want to violate your citizens' privacy rights, go for it, I think that that's a tragedy. Yeah. So my ask from governments would be to be conscious and to use their power to regulate for human rights around the world.
Maybe we should ask the so-called Freedom Online Coalition to put its money where its mouth is and make that commitment, right?
That would be great. And the last one, this is not as clearly articulated, but I would like to see it happen. So we're moving to a world in which we're talking about some sort of rule of law process, appeals and all of that. But I think that in doing that, we need to pay attention to legal theory, to the idea of an independent arbiter, and we really need to put a little bit of thought into what it would take to make that appeals process mean something. And for it to mean something in terms of enforcing human rights standards and not necessarily whatever standard each company comes up with.
Maybe we need a Monroe Price moot court to become a real international human, freedom of expression court or something. So Peter, I need to give you a chance to respond to some of this. And Agnes, she's the boss. She gets to say something. And there's a mic there. Maybe somebody can get it to her, and then we might be out of time.
I do have responses, but I'll save that for private discussions. You mentioned NetzDG, and I did want to make sure that people were aware of that. I mean, at a conference devoted to free expression, I think I'm a little bit surprised, candidly, that we haven't been talking about that more, because it's something that's quite troublesome from the perspective of freedom of expression. As I think people know, it's a German law that came into effect at the beginning of this year and gives people the right to report illegal content directly to platforms. The platforms are under a heavy obligation to remove illegal content, clearly illegal content within 24 hours and other illegal content within 7 days. The difficulty of it, and the troublesome incentive here is that it puts companies in the position of making that determination of what's illegal or not illegal. And given the penalties involved, there's reason to think that there may be some over-removal. And this is something that free speech advocates should know about, and we'd like to draw attention to.
Absolutely. So we'll go to Agnes, was going to say something, and
Not
we
because
may be out of time.
I have to rush, and just please come and join us for the event this evening. We are hoping that you will all be there to for the ceremony. No, I just wanted to make maybe a couple of points. Somehow I wonder if we're not zooming too much on details already, and whether or not we have the picture right, the overall system, so we're zooming on appeal. But, just the notion of a global regulation, we don't really have a sense of it. So, and I don't have it, but I do feel that somehow our capacity or propensity to get to the details may be driven by the fact that we don't quite know how to make the overall bits and pieces work together. And as long as we don't do that, I'm not sure it's going to work. Second, I just wanted to put a few more things on the table. We do not talk enough about the rights of the platforms. And I think that as long as we don't bring that into the discussion, we're missing a fundamental element. And I'm not talking their rights from the American First Amendment standpoint. I'm talking about it from an international human rights standpoint, where it is acknowledged, including in the ICCPR, the International Convention, that those private actors have some rights, in addition to have actually specific duties. And they have been around for 70 years or so, those instruments, a bit less for the ICCPR. We have not, and it's not just for freedom of expression, it's more generally for the human rights world, we have not really understood or taken time to unpack what these are. They were already there in the discussion in 1948. When you go back to the original work of the drafters, it's fascinating to see how very worried and very focused they were on particularly on the role of the big media companies at the time. And we still have not really thought through of what are those specific duties and what are the rights of those companies. Thirdly, I just want to point that there is a framework in human rights term which I think could be helpful in unpacking the duties of the specific duties, which is the right to respect, the right to protect, and the right to fulfill. And whether or not there may be more to do there, because we can't ask the platform to do everything. And if you look at those three obligations and try to have a complementary model of obligations across the state and the private actors and the users, by the way, maybe we could have, I'm not talking about extraterritoriality there, which is another. And fourthly, I really, really think, and I'm glad Facebook is here, I think, yes, it's very important, individual speech, and so on and so forth. To me, the biggest responsibility right now is with regard to those fragile settings, whether they are communities, countries, regions, where Facebook, not as its own, by the way, I don't think Facebook is responsible for what happened to the Rohingyas, but in those fragile settings, Facebook has a responsibility to understand the impact of its platform. And I don't think you need to do that, just when the data start coming. I think there is already around the world a couple of hotspots. There are people who are trained to tell you that in 10 months from now, because of this election in this given place, it's gonna be bad. I think it will be possible for Facebook to start thinking in terms of risk prevention and to do that on a 1 year, 2 year, 5 year basis, on the basis of countries, on the basis of communities at risk, on the basis of moments that are risky, where the platform can become a tool for greater harm than just, quotation mark, a speech harm. And I do think that you do have certainly the brain power and the money to invest into developing this risk prevention system, which would do a great deal towards minimizing the misuse of the platform and really its negative impact on democracy, on fragile democracies in particular.
Thank you, Agnes. And the UN Guiding Principles for Business and Human Rights, emphasizes risk assessment, which is really basically risk prevention, that part of the conversation I think that's been going on even in this country is the need to do risk assessment kind of beyond just kind of direct government requests and the kind of impact that the company's having. And also with the UN Guiding Principles, of course, the overarching framework is governments have the primary responsibility to protect human rights, and then companies have the duty to respect. And the problem is that government, a lot of these problems we would not be talking about if governments were doing their job. It wouldn't solve all of the problems, but it would, governments are failing to govern in a way that is compatible with human rights. And so, again, until that happens, we're kind of playing defense, right? And which is, how do we use these tools to get governments to respect human rights, to protect human rights as well in the middle of all this? But I think, do I have time to let people say a few closing words, or do we have to leave? We can do that? Okay. I'll let people just say very quickly if you just want to have a closing comment to what Agnes just said, or if you have some further thoughts about kind of the relationship between the obligations of governments and companies and how we move that forward.
Well, I just actually wanted to mention when I was giving my presentation that given the state of the context of certain countries in Latin America and the difficult political processes that we're going through, all the efforts, and the majority of efforts of the Office of Special Rapporteur and other partners are put into the judiciary and the role of courts to really take into the international human rights norms and apply it and build little by little more protections to freedom of expression online and take while these conversations and other forums continue.
As I said, we're moving from the question of applicability of existing national laws on cyberspace to a situation where we have to develop, and most of the discussion has been going in that direction, new norms, new tools, potentially new institutions, and it's a completely new environment. I think the remark by Agnes at the end was absolutely on spot, but we need the range of discussions from the general architecture to the very concrete elements, because in our experience, what is emerging is that the more concrete you become, the more you're forced to formulate the underlying principles. If you stay at the level of underlying principles, you can have a debate that goes on forever. And finally, I would just want to pick on two things that Chinmayi said. One, I like very much the notion of hyper context. This is a very important element, and when we talk about fake news, I would say that we're confronted with a problem which is hyper-targeted disinformation. And this is a very new thing, the fact that you can do it in a way that will be not notified by other people.
Right.
And the final element, to come to what you were saying, there's a tension here that is very difficult to reconcile, because on the one hand, civil society actors are telling the companies, you shouldn't be making the first decision on things that touch upon human rights and so on. We don't trust you enough. And at the same time, and in the same move, they say, but you should be the ones who actually become an appeal mechanism to actual court decisions in countries where you will be saying the court decision is a wrong court decision because of human rights principles. And we want both, and the problem is that the two are difficult to reconcile.
Okay, Chimay.
Okay, I'm going to disagree, and then agree with people. I would say one is that unfortunately, the platforms are being weaponized in certain contexts, and I think that means that there's a degree of responsiveness that we want from them. But I would definitely not say that the platform should be the final arbiter of whether that is the proper way to act. I think that that's really the challenge for people like us, that who should be the arbiter? How do we compose, how do we put together an independent arbiter that is the most likely to fight for human rights? And that, for me, is not the platforms. Two is, I think that what I agree completely with Agnes about this risk assessment question, and I think that that's a route that we do need to go down with the companies. But I think there's a minor distinction between what the UDHR conceived at the point of drafting and where we're at, which is that mass media companies were speakers and platforms are content aggregators. Yeah. And that there lies the root of the problem. But I think it's valuable to go back and think about what else they were thinking and how we can put it together with the new world. I think that's about it from me. But sorry, I just want to underline just one more thing, which is that I do feel like governments that are committed to international human rights can do more.
That
And we
they must and should, yes. Yaman.
I just want to quickly say that rather than harmonization, we will see more and more fragmentation. And unfortunately, there are legal differences, and each country is different. And Turkey is, for example, unique. And following up from what Bertrand said, last year in 2017, there were 20,000 individual blocking decisions issued by the courts, 20,000. You won't reach those numbers in any other place. But there is no due process in Turkey. There is no free judiciary. They're under control by the government and everything. And then I talked to representatives of Twitter, did in the past with Facebook as well. They keep telling me that there is due process and they receive these decisions, so they need to act on it. That's not true. But they need to take a point rather than handshaking with these repressive regimes and government for the sake of their businesses. IS reminded of these UN policies. There are at ILO level, OECD, there are these soft conventions and principles. They're difficult to act on. But we did, for example, 3 years ago, we notified Twitter through a notary public in Turkey, their lawyers in Turkey, and reminded them of their responsibilities and to refrain from offering inferior services with their country without policies. We will do more of these because they need to be constantly reminded of their responsibilities. But it's not an easy task. But that shouldn't stop us from going after these companies.
Chris?
Really quickly, I think that we've been focused mostly on law and policy here today, and I'll just say from the private platforms perspective, there's also a huge technological and architectural component to this, in that platforms are free from some of the limitations that state actors face when they want to mediate and moderate content. That can be a bad thing, right? They could over-censor because they're not subject to the same kinds of free speech protections either. But it can be a good thing in that they can really help to empower users by developing technologies that permit filtering and muting and blocking and those sorts of things. And so I'd encourage the private platforms, I know Facebook's been doing this, to think about that as well.
Peter?
I mean, I guess if you boil it all down, our goal on the policy team is to try to maximize the good and minimize the bad. And that's what we're seeking to do with the tools and the policies that we come up with. So it's been quite helpful today, the discussion. I've picked up a lot of points that we'll be able to take back and discuss. I really appreciate it, and hopefully will lead to better engagement with all of you.
Thank you all. You hung in there. See you at the ceremony.